December 15th, 2015. Today we met with State Attorney regarding the FWC Constitutionality. Attorney General Bondi on Twitter, and then I gave her Twitter handle. Members of the media who would like to contact the office can do so by calling, and then I gave the number. We have been working on this since March of 2005, when we first learned that the Florida Wildlife Commission's authority over captive, non-native wildlife did not come from the Florida Constitution, as they claim, but rather came from the statutes. The reason that is important is that the Florida Wildlife Commission has managed to avoid a ban on the private possession and pimping of tiger and lion cubs by saying the citizens of the state have no right to petition the legislature for a ban. On March the 18th, 2005, I spoke with Curt Kiser. He was a former state senator, by phone, and these were the pertinent details from that conversation. Number one, Curt was the first person to draft legislation for any regulation of exotic animals in the state of Florida and was involved in the process that elevated the Florida Wildlife Commission from being a state agency called the Game and Freshwater Fish Commission to having constitutional authority under their new name of the Florida Fish and Wildlife Conservation Commission, FWC for short. 2. He says that they have had constitutional authority over native animals since long before that, but that even today their power over non-native species, the one I'm concerned about, is not constitutionally given, but is rather legislatively given. 372.921 and 372.922 seem to bear that out in the Florida statutes, and state that for a person to own or exhibit an exotic animal, they must meet the standards set by the Florida Wildlife Commission. That gives the Florida Wildlife Commission the authority to determine who may or may not own or display them, and how that should be done, and seems to leave in their hands the ability to define which animals fall into which classes, Class 1, Class 2, Class 3. 3. Because the Florida Wildlife Commission has the power to do what I want, which is to reclass all exotic cats to Class 1 and require a commercial zoning for acceptance of applications to exhibit, he suggested that I meet with David Meehan, one of the FWC commissioners who lives nearby. The meeting should be at Big Cat Rescue so he can see the enormity of the problem firsthand, and so that he can see I'm not just some rabid, crazy cat lady. Number 4, Curt suggested that I use his name to affect this meeting, and that I could do the same with the FWC's general counsel for the past 20 years, Jim Artista. He suggested that I let them know that I am trying to work within their framework first, because they are protective of their constitutional power, and even more so of the perception of that being all-encompassing, and may be willing to work out something that suits my request so that they are not in the position of having that ability to be in charge taken away from them by the legislators. Curt said he would call Jim and let him know that I would be calling soon. He warned me that David Meehan is an avid hunter, as are all of the FWC commissioners, and they don't want to assist any proposal that could be a foot in the door for us bunny-hugging types to stop them from hunting. To tell them that the reason this legislation is important is because canned hunts are the only place that unwanted lions, cougars, and tigers can go is likely to fall on deaf ears, even if they wouldn't personally participate in shooting an animal in a transport cage. He said another reason that it would be hard to overturn any of the FWC's constitutional authority would be because of the power groups such as the NRA, who want the rules of hunting to be controlled by those of like mind, and not the majority of the population who could influence changes within their voting power. This was how he's outlined to Pam Bondi. He also printed up every case, memo, and note on the subject, and included them in a tabbed ring binder, so that all of the heavy lifting has been done for them. All that they have to do is read it and issue an opinion stating that the FWC's power over non-native animals comes from the legislature and not the Constitution. So these are just bullet points. I don't know how much sense it's going to make. Beyond the presentation outline. area you don't directly regulate, key to enabling us to put a stop to it, show the book, tell a few stories. Reasons why regulation does not work and cannot work are the rules, what you can see, cite for years, few are taken to court, most settle for nominal fees, very few lose their license, then another person gets a license and it all starts over again. The Florida Fish and Wildlife Conservation Commission governs, and he lists all of those things. Need to walk through the history of it. The 1942 Constitutional Amendment initially empowered predecessor agency Game and Freshwater Fish Commission. The language was, quote, birds, game, fur-bearing animals, and freshwater fish of the state of Florida. The FWC tried to enforce regarding captive animals. The 1960 Florida Supreme Court said constitutional power was not over captive wildlife in Barrow versus Holland. There's a green tab on the book there. 1967 legislature passed a statute to give power over captive to address the Barrow issue. 1968 Constitution granted authority was amended. The language wild animal life and freshwater aquatic life is what they used. The 1974 Constitution was amended. The language kept wild animal life in the language. 1999, the FWC created by merging with the GFC. In 1999, the FWC was created by merging the GFC with the Marine Fisheries Commission. The language was kept the same, wild animal life. The agency claims constitutional amendment gave constitutional power over captive animals, so the claim change in language from birds, game, fur-bearing animals to wild animal life means control over captive comes from the Constitution, refer to coming from the Constitution and from the statute. In 2007, Carla Olga, Assistant General Counsel, her memo cited cases, and the significance was, if it's from a statute, we can pass a ban. If it's from the Constitution, we need a constitutional amendment. Oglo memo cites administrative law cases. I read, the language changes captive not to make sense, wild animal life, animals in the wild. The purpose of forming the commission was conservation, which was wildlife in the wild. The West editor notes in 1999 the purpose of unifying the state's natural resources conservation efforts. The cases don't support the position that the FWC has taken. Johnson Pope did a memo on this as well that supports our position. The problem is if we tried now to get a bill banning private ownership, the FWC will tell legislators that they cannot, and the legislators will listen, because it's always easier to say it's not my problem. Request, review the memo and consider issuing an AG opinion that agency power comes from statute, not the Constitution. And then the rest of this is private from a private donor. And it was talking about how whenever we do challenge the FWC, they typically come after us and try to force us to conform to some law that doesn't exist, like they did several years ago by saying we could not have live cameras on our rehab bobcats because they considered that to be exhibition. And we fought it and fought it and fought it, and they made us go through all kinds of hoops and made us drive all the way up to Tallahassee to deal with this. And as we walked through the door, they said, you know what, you're right, doesn't apply, and you guys can keep your cameras. So it's just, we've been through this so many times where we really need to end the abuse in Florida of these big cats. The FWC has not wanted to rein it in when they could, and so we need to have someone determine that the legislature can actually take action. Florida is the only state in the entire country that does not allow the people of the state to weigh in on how animals should be treated in their state. Wild animals should be treated in their state, which I find to be just beyond belief. But we're still here. I'm saying all of this in 2021. I finished reading when I talked about the AG opinion a minute ago from my diary from back in 2015. So as you can see from this, since 2005, I have been struggling to try and get the state of Florida to ban the possession of big cats, or at the very least, reclassify all of the exotic cats as class 1 so that the people who have them at least have to have a USDA license, which means at least once a year they're going to maybe get inspected, and they'd have to have things like pet care and a vet on hand or on their contract, and safe caging and that sort of thing. So we're still fighting it. We're going to keep fighting it. Love you. Mwah!